Without further ado, I'll give a brief introduction to the ABA ICC project, and then a brief, as I said, introduction to the ICC, and we'll proceed to questions. As many of you know, with nearly 400,000 members, the American Bar Association is the legal voice, is the voice of the legal profession in the United States and at home and abroad. The ABA Center for Human Rights is as the name indicates, is kind of the focal point on human rights issues for all the ABA, over 3,500 entities that are within the ABA. And so first and foremost, the ABA Center for Human Rights leverages the potential of the American legal profession for human rights purposes. But additionally, we operate our own programs on particular issues where we see there's a unique need. And one of those is the ABA International Criminal Court Project. As some may also know, the ABA since 1978 has had pro-ICC policy passed by our 550-member House of Delegates. Most recently, we've urged the United States government to join the International Criminal Court, and additionally to find ways to support the International Criminal Court absent ratification. The ABA ICC project is essentially the fulfillment of that policy purpose. And all of you should have seen this pamphlet. I won't go over all the details of what the ABA ICC project does, but specifically it's both advocacy and education, which this is a specific example of, and then also where appropriate, working with our international partners on practical assistance that we can help with the ICC when requested to do so. Let me just give you a brief smattering of what the ABA ICC project has been up to lately. Back in early April, we welcomed the prosecutor of the International Criminal Court, Madam Prosecutor Fatou Bensouda. We did a congressional briefing with her in early April, and had over 40 offices from Capitol Hill represented there. Additionally, we did a public event in conjunction with the Aspen Institute, and this was Madam Prosecutor, Justice Richard Goldstone, Ambassador Stephen Rapp, and others, and Judge Patricia Wald was at this event. We had over 300 people, and it was a very successful event, and I encourage you to look at the video of the event on our website. While I speak of the website, please don't go to our website now. This new one is forthcoming. You'll go to a dead website, and I don't want you to think that we're completely ineffectual. It's coming up soon. And lastly, I'll point out that in June 19th, if I have the date correct, is the second annual ABA Human Rights Lobby Day. This is where ABA members come from all over the country to lobby their representatives on human rights issues, and we're happy to say that one of the two issues picked for the second year in a row is greater U.S. engagement with ICC. Let me introduce our distinguished guest here today, the Registrar, Herman von Hebel of the Netherlands. He was elected on March 8, 2013, and sworn in on 18th of April 2013 as the new Registrar with a 5-year term. Prior to the ICC, he was the Deputy Registrar and then became the Registrar of the Special Tribunal for Lebanon. And he's also served as the Deputy Registrar, then the Registrar of the Special Court for Sierra Leone. And from 2001 to 2006, he was a Senior Legal Officer at the UN International Criminal Tribunal for the former Yugoslavia. Prior to his work in the international arena, Mr. von Hebel had various positions within the Dutch Ministry of Foreign Affairs and Ministry of Justice. During that time, he was a part of the Dutch delegation at the Rome Statute, which of course led to the establishment of the ICC. And he studied international law at the University of, and I'll probably mispronounce it, Groningen.
Very close.
Very close to the Netherlands. And there's one special distinction I'd like to say. And first of all, he was my very first boss in the field at the IC2I. That is not the special distinction. That usually gets people early retirement to be my boss. But his special distinction was that my name is actually a quite odd thing in the Dutch language. And I remember meeting the registrar, and he looked at me and he says, "Oh, you're Kip." And I said, why did he say that oddly? And I said, well, why did you say that in such a way? He goes, "Oh, you'll find out." And as I was walking back to my apartment, I walked by McDonald's and I saw a big sign that said Kip Nuggets on sale. So my name in Dutch is chicken, so obviously it's been quite a good laugh in the Netherlands. So with that, we'll get to the questions. Again, it's informal and conversational. I'll ask questions of the registrar, and he'll obviously give us his answers, and we'll go to questions and answers thereafter. Now to start, Registrar, Mr. Registrar. Let me begin with a rather elementary question. What is the registry? While many of us here may be familiar with the duties and responsibilities of the registry, they're maybe not so familiar with the concept of a registry. Can you please briefly lay out where the registry stands in the ICC infrastructure? What are its main responsibilities? And generally, how does the registry fulfill its mandate?
Yeah, thanks very much, Kevin, and thanks for the nice introduction. And I clearly do recall our conversation that we had when you joined the ICY for a little while. Yeah, the registry, I think it's a very confusing concept, actually. The legal system where I come from, the Netherlands, and the registrar is basically the person who sits in the courtroom, actually assists the judges and makes notes, summaries of the proceedings in order to assist the judges to taking their decisions. There's a lot of things that I do, but it's certainly not one of my jobs. Basically, in order to understand the role of the registrar, you have to understand that the ICC, and the same applies to all the other international tribunals and courts, is sort of a standalone jurisdiction. It has everything in there, from detention to security, external relations, budget and finance. It is an all-encompassing legal system. So it has elements of Ministry of Justice, Ministry of Interior, Finance, everything in there. And maybe the best way to describe the role of the registrar is in a negative way, by simply saying, it does everything that a judge doesn't do, that a prosecutor doesn't do, and a defense counsel, and in our case also legal representative of victims don't do. But they have very specific tasks that everyone over here, of course, fully understands. Everything else, in order to make a court functioning, is basically a responsibility for the registry. And so I often also describe my job in a very concrete way. If things go well, everyone, of course, is able to take credit for how things go. If things don't go well, you can always point the finger at the registrar for not having done it well. So that is basically the job. It has, in reality, three major elements. First is the pure administrative part, HR, budget, finance, these kind of things, IT. That is maybe not the most exciting part, but a crucial part, obviously. The second is more the traditional court management support functions. That comes probably closest to what the concept of a registrar brings about. That is making sure that there is fair distribution of documents, disclosure obligations for the OTT, facilitating all that process, but it also includes the detention. It also includes the Victims and Witnesses Unit, and we'll talk about that later. Victim participation process. There are a couple of other things in there as well. So that is really everything that really relates to in and around the courtroom that is required in order to make the judges and the proceedings go well. That is that part. And then the third part is something that is certainly not part of the normal registrar's function on a national level, and it is more the external face, so to say, of the court. And it goes to issues of our press office, our outreach activities, reaching out to affected communities in the countries that we're working on, and that is an incredibly important part, but also external relations, cooperation issues, so anything that relates to cooperation, any judicial decision that has an element of cooperation with the situation countries where we do our investigations has to be channeled through that registry, and that's where I'm responsible for as well. So that is more the public face of the court. And so everything is in that registry, and you can imagine that requires a lot of staff that we have around in The Hague.
Well, thank you for that. And going off that, some of the parts you talked about state cooperation leads nicely into my second question. And as our program is titled The Practical Challenges of International Criminal Justice, and given that we're fortunate to have you today and year-long history and these types of practical challenges, I think the best way to start is to get what you think are the priority practical challenges that the ICC is facing. And in asking this question, I hope for the benefit of the audience, I think it's good to talk about state cooperation, because at the domestic level, criminal litigation is already complicated, but it takes a whole nother level of complication at the international level when working with states. And so I always think that's a very good point to bring up to an audience maybe not so familiar with international criminal litigation.
Yeah, no, I think, and thanks for the question, because it's one of the crucial elements of the court. cooperation with states is basically the Achilles heel of our functioning. Things in The Hague can work pretty well. Of course, everyone is there, prosecutor's office, judiciary, and the registry. But by the end of the day, without cooperation of the states, we won't be able to succeed. And that is where really a lot of challenges are coming up. You mentioned the different situations that we are working in, including countries that have been referred by the Security Council. Everyone knows about President Bashir, other cases where people are indicted by the court. There's an obligation to bring the people to The Hague to make sure that they face trial and get a fair trial in a reasonable period of time. But in order for us to be able to start proceedings, we need that person to be physically present in the court, and that is where we need the assistance and the cooperation of states to actually implement arrest warrants. And frankly speaking, most of our arrest warrants at the moment are not implemented. We have about 8 or 9 people that are actually based in The Hague that have been arrested, that have been brought to the Hague, but a number of them are not. In addition to that, one of the major challenges is also the protection of witnesses and the relocation of witnesses, where we again are completely dependent on states. We can't do our own witness protection in The Hague or in other parts. We need to rely on states for that cooperation, and these are really crucial challenges. Some states do cooperate, others don't do so or less so. And it's basically a daily challenge in order to get the cooperation in place.
Let's stem right off that last point. Let's get into witness protection.
Yeah.
That has been, particularly the McKinney case, has been in the news everywhere. It's been a focal point of continual stories, and I know an issue that the ICC deals with on a day-to-day basis. So on the witness protection, what are the specific challenges?
Yeah.
What is the registry? I know that you're doing such great work in reorganizing and such within the registry of its methodologies and such. What are the first steps that you've taken? And specifically going back to where we just were, what can states do to help more?
Yeah. Just to give you some figures, at the moment we have over 700 people that are officially in our protection program, and that is witnesses plus family members. And then you refer to the Kenya case, and a substantial part of those are related to the Kenya cases that we investigate. At the same time, as I mentioned before, we can't do the protection ourselves. We can do part of it, but we rely also on states. And we have only so far 14 states, with which we have entered into relocation agreements. And even those agreements are not necessarily very strongly binding agreements. It's basically a willingness of states to favorably look at any request for a witness relocation. So basically, what I often say, we with the back against the wall. We have a huge number of witnesses that we have to protect. At the same time, our possibilities are limited. We are dependent on states, but we also have to realize, and certainly for proceedings before the court, much different from national proceedings where you may have a lot of forensic material, other material. The trials that we have are largely, or sometimes almost exclusively, relying on witness testimony. That may be a weak basis, and I know that the prosecutor is working on a new strategy to change that practice a bit. But without witnesses, we don't have trials. And if witnesses don't have the guarantee that any protection that may be required is actually provided, they won't come up, and then we won't be able to run our trial. So that is, I don't think I can explain more importantly how crucial witness protection is. And that is I think at the moment, one of the biggest challenges that we have in the court.
Certainly. Getting to another topic that I know the registry handles on a day-to-day basis, and is part of its mandate, is victim participation reparations. That's something I think within this American audience, but of course we have others from around the world. But it's something that's unique, and so maybe you could talk a little bit about the extent of victim participation reparations system. Aside from my former employer, the Khmer Rouge Tribunal in Cambodia, the ICC is a novel territory. This is the first time that victims have representatives and that the actual reparations are something of a potential end of a proceeding for them. So it'd be great to talk about the system. What are the challenges of that new novel issue the ICC is facing?
Yeah. Here again, just to start off with a couple of figures. You know, since the court started and since we have been working on a number of cases, we have, I think, over 15,000 people that have applied to participate as a victim in the different proceedings. But that shows again, at the same time, the challenge that we have. You know, it is. I think it's a big challenge to get them actively participate and to do it in a way, as the statute also requires, to do it in a way that does not harm the proceedings and the rights of an accused. Everyone will understand that if you bring every single victim in the courtroom and have him or her have his or her say, then proceedings, which are already long, will of course go way beyond the acceptable limits. So you have to organize it in a different way. And sometimes within the court and also within the state's parties, I feel there's an element of criticism about the victim participation. I don't agree with that. I think it's an incredibly important element, and those figures actually show the success of it as well. It shows the hope that people out there in the different countries have, in that the ICC is actually bringing justice to them, and that is something that is incredibly important. At the same time, how to organize them in such a way that the proceedings can run smoothly, and frankly speaking, we're still struggling to really get it right. We start off by having victims apply through application forms and all that. These have been standardized, but then in the different pre-trial chambers that are working on it, because of the fact that in some cases a few hundred, in some it's a few thousand and whatever, chambers have looked at different ways of actually making it happen in that particular case. And so at the moment we are struggling a bit with the fact that there's not that much harmony, not that much of a sort of one consistent approach. And I actually engaged with the judges recently in the discussion in order to ensure that we have a uniform approach, and then look into how we can make victims participate. An element of collectiveness simply has to be part of the system. There's no way to avoid that. But then you have to look into how you can do it in an effective way. Maybe you can organize different groups, you know. Victims of sexual crimes is often, unfortunately, a distinct group in almost every single case where we deal with people that have been subjected to murder or torture or pillaging and all that. Maybe you can do it by different categories, but some sort of collectiveness you have to do. But at the same time, making sure that victims still feel that they're just more than just a number, but that they actually do participate. So communication here again, outreach, these kind of things are crucial elements in that process.
Maybe also discuss within the Rome Statute and what falls within the Registrar mandate and other parts of the ICC about reparations.
Yeah.
What is the potential there? What are the types of issues that, I know there's only been the Lubanga conviction and work on reparations with that, and Katanga's going to, has been sentencing, but there'll be other issues handling that going forward. So maybe discuss a little bit about reparations.
Yeah, I think as you mentioned, I think it's still at early stages. The first case that we have so far is now at the appeal stage, and hopefully in the next few months will lead to an appeals judgment on guilt or innocence of the accused person is coming in a few months. But and in that case, it's probably not. Well, depends on whether that is really a landmark decision or can become a landmark decision. Because Lubanga in itself is not someone with a huge pot of money somewhere lying out there. You know, another case that we have, the Bemba case, is in that respect a better one, in the sense that Bemba was a prominent person in the DRC, a former contender to become president of the DRC. However, the crimes that we're looking into are related to the crimes that he allegedly committed in the Central African Republic. But Bemba is a wealthy person. He doesn't hide that himself either. And so that might be a very interesting first case where we can actually determine what does reparations mean for victims. And that's probably in the course of next year, so that we hopefully have more clarity on that. But at the same time, as something that's is sometimes forgotten, which I think is a crucial element, under the Rome Statute, we also have an integral part of it is a trust fund for victims, and they have the mandate to deal with reparations when the judges will order it. But at the same time, they also have what we call an assistance mandate. So based on voluntary contributions from governments, we have been seeing an increase in millions of euros that are being given to the trust fund. They are able to already reach out to affected communities. These don't have to be victims of the specific crimes that we are dealing with, but they are victims of crimes in the countries where we are investigating. And those projects that they do are absolutely fascinating. Just to give you an example, I was about 4 or 5 weeks ago, I was in East Congo in Bunia, and I saw a project organized by a local NGO financed by the Trust Fund for Victims, where a group of 30, 40 women who have all been the victim of sexual crimes, some of them have been sexually enslaved for a certain period of time, etc. Really gruesome stories, obviously. Have been in this project, which basically was focused on first getting sort of self-esteem back, but also in many communities in Africa, it means that once you're known to have been a victim of sexual crime, you're almost also excluded from your own society. So there has been a wider circle of people that have been included in this project in order to get them back into society, to be recognized into society, to give themselves an own living, etc. That is just a fantastic success story, and that is also part of the Rome Statute system. And I think there's a lot to be said for intensifying those activities.
Just one small point on that. I know that the Trust Fund for Victims is working on just private donations from people out there in helping streamline that process. So I just, almost as a PR point, I think that's the type of
Bring
thing.
it on,
Yeah, that's the type of thing that I think civil society can work on about, is advertising that the Trust Fund for Victim is out there, is doing this work that is separate from any one particular case, but within the countries, the affected countries. So that I'm glad that you brought that up. Now, I'd be remiss here at a bar association not to talk about opportunities for external counsel at the ICC. For me, the first thing that comes to mind is a list of counsel for defense and victims lawyers, but there, as I understand, many other opportunities for outside counsel. Can you discuss those types of opportunities? What is that process like for a lawyer from, I know, anywhere in the world to become a part of the list of counsel, these other opportunities? And what are the resources available to them if they actually do be able to take on a case? Because I know from past work that I've done at ad hoc tribunals, the ICC system is more robust. There's a lot of different procedural rights and different resources available to counsel.
Yeah. No, I think that's a very important aspect. We have actually 2 sections within the court that deal with certain aspects of that, or even more actually. Well, first there's of course the role of counsel for the defense of an accused person. We have a list of counsels, so everyone who needs a number of qualifications. I don't know the details, but they can definitely be found on our website. You have a number of years of experience, serious litigation and all that, then you can put your own name on the list. But at the same time, I think we have about 400 or 500 people on the list at the moment. But given the fact that we have a limited number of cases, chances of getting from that list and actually work on a particular case is not that high. What I actually would be looking forward to, and is also in my communication with counsel that I've been talking to, is that I think there's a recognition that the way we provide services to counsel can actually be improved. I think we can provide more assistance in terms of their own investigation. They often have to go into countries where it's, things don't always work the way you probably have been used to back home in your own jurisdiction, and that's where the court can improve its support activities. But I think there's also something that counsel are coming from different jurisdictions, but there is not one really sort of a bar association within the court itself. And one of the things I've really been been pushing for is, hey, council, get yourself better organized and do establish a bar association. Maybe also have a system of admission in a list, and where I would rather rely on the self-organization of council rather than having the court determine that for council themselves. And I think there's a certain sympathy for that idea, but it's a question of who's picking up that idea. But as far as I'm concerned, I think we need to strengthen the position of counsel within the court. On the one hand, of course, representing accused persons, but also, and that's a very important other aspect, representing victims in the field. And as I mentioned before, when talking about victim participation, there are different systems in place. I don't think we have yet found the golden solution for all situations. But what I strongly believe in is that you do need to have counsel in the field that are in daily contact with victims and that also know the situation very well. So often you probably have to rely on local counsel, but at the same time, of course, also international counsel that know the system and behave very well. But how to organize being in the field, being visible to victims, and at the same time participate in proceedings which normally are in The Hague, that is still a bit of a challenge.
My next question, I like to call a buffet question. You can choose how you would like to answer it.
All right, good.
Every part of this question can be a whole program in and of itself.
How much time do you have?
Well, I'll leave to you to pick each one, but it's pretty much ripping from the headlines, where we see the ICC in the daily news flashes. And first and foremost, and excuse me, let me say that the ICC's involvement or non-involvement, in specifically the registry involvement or non-involvement in these situations, and just tell us what the status is on these things, so I think the audience would benefit from that. And first is the 3-year-long civil war in Syria. We've seen that there's been efforts in the UN Security Council. How do you see those things? The Ukraine, the continued interest in Ukraine. The Nigeria, which we've seen has been very much publicized by the abductions of schoolgirls by Boko Haram, and I know that there's a preliminary examination in Nigeria of the ICC. And then additionally, the recent news of the Iraq probe as it relates to UK armed forces in Iraq. These are all can be all quite sensitive issues, but just in those, where do each of these stand? And again, I defer to you to choose your priorities.
Yeah, I think all four actually together show that no matter which paper you read, you constantly see that there's a link between those developments and some of the horrendous developments taking place in particular countries, whether it's the abduction of the school children in Nigeria or the daily commission of serious crimes in Syria. It doesn't matter. There's always that kind of link to the ICC, and that also means that although you are a judicial institution, you're also always operating in a political environment. And as a court, you have to be extremely careful that you stick to your judicial mandate and don't get involved in politics. But yeah, Syria, I think for me, Syria shows how still imperfect the ICC system is. Because this is one case that actually shows why the ICC was established. Then it is because of the kind of crimes that you see in Syria taking place. And why then is the ICC not investigating? Well, because Syria is not a state party. So the only one who can bring it to the attention of the ICC is the Security Council. We've seen a resolution, what was it, last week or the week before, a veto by China and Russia. And it shows the imperfections of, well, probably also the Security Council decision making, but also the ICC system in itself. And it's only, unless of course Syria would decide to become a state party, very unlikely scenario, you have to wait for a change in the Security Council, which is probably another very unlikely scenario, at least in the foreseeable future. But it's an element of frustration for us as well, because you see the crimes being committed. and at the same time you can't do anything about it. Ukraine is a different situation, because we had a couple of weeks ago, probably a month and a half ago, a referral by Ukraine. Ukraine officially is not yet a state party to the ICC, but the government of Ukraine has filed what we call an Article 12.3 declaration, so they accept on an ad hoc basis the jurisdiction of the court. But they made a very specific declaration only for the period of, let's say, November last year till the end of February of this year. So that is the highlight of the revolt leading to the stepping down of the previous president and the entering into force of the present government that has now prepared the presidential elections that we've seen last week. So that is a period of basically about 100 or just over 100 victims in that process of transition. The court has accepted that declaration, and now it's for the prosecutor to do a preliminary investigation, also see what, as you mentioned, the South Court is a court of last instance. Is Ukraine investigating themselves? Are they willing? Are they able to do so? Once we have determined that one or two of them do not apply, then the court may step in. And that is often a process of cooperation between the prosecutor's office and the local government. Nigeria, just briefly mentioned it. Nigeria is a state party. The prosecutor is able to pick up on those issues. She has picked up, she has made a statement earlier on. And there again, it's at the moment under investigation, or examination as we call it. And then here again, it's a question of, is Nigeria actively able and willing to investigate this crime themselves, or is it something that comes to the court? And what was the last one?
The UK.
The UK, that's an interesting one. And there again, it shows how complementarity works. Complementarity basically means if national courts and jurisdictions can do their work, there's no role for the court. Undoubtedly, there might be political voices in the UK of saying, hey, what is happening over here? Why does the ICC get involved? But there are reports which make the prosecutor believe, hey, wait a minute, there are crimes that may have been committed. The allegations are serious enough. I have to investigate crimes wherever they take place and whichever state is involved. And the UK is now simply preparing themselves in order to show that they're able and they are willing to investigate those crimes themselves. And if that were to be the case and the prosecutor were to accept that, then it also means that there is no role for the court to further continue that case. But that is how complementarity should work, and I'm confident that we'll get to the right result with that case.
Certainly, it's as you duly point out, a great opportunity for complementarity to be put on display there, as it is in other situations. Now we'll switch to something here that in this country is, and in this audience is obviously an issue that was discussed, and that's U.S.-ICC relations.
Yeah.
The U.S. is obviously not a state party, but this situation has changed. Most recently, under the last term of the Bush administration, there was a warming of relations, and then of course under the beginning of the Obama administration to now, the relationship has been on an upward trajectory. Are there reasons for the U.S.-ICC relationship to be enhanced more, in your opinion? And where do you see opportunities for that to occur?
Yeah. No, I must say that and I agree with you that the relationships have really been majorly improved from where we saw it just after the Rome conference, discussions here in Washington, to where we are now is a serious difference. And often what I'm saying is, yes, the U.S. is not a state party, but if we would get so much cooperation from some of our states parties, we would be much better off. So the mere fact that your state party doesn't say it all, exactly. I do see there is a huge amount of support And recently we've seen an increased effort again in order to try to chase down Joseph Kony in either the north of Uganda or somewhere in Central African Republic. These are concrete efforts, and again, given the fact that we don't have our own police forces, we don't have our own military to go out in the field and try to chase down people that are under arrest warrants, these initiatives are very welcome for us in order to see that hopefully we will be able to achieve an arrest warrant and bring then hopefully also that person over to the court. I think there are also many other ways of cooperation, exchange of information, etc. Wherever I go in the countries where we have investigations, there's a standard exercise of meeting with the diplomatic community, US embassies over there, and there's so many examples where the US embassy, sometimes small projects, but it help us out in time in showing what our work is being done, and sometimes we ourselves, because of the sensitive nature of our work, we can't communicate with civil society or with the public, and that's where through the finance of US embassies, again, sometimes small projects but big results, there are possibilities where the US embassy or other embassies or embassies together work out in terms of getting that messaging done that we can't do ourselves. And these are, in my view, very positive and constructive ways. And as far as I'm concerned, this is the right way forward. And I think there's a lot more that we can do. And I'm quite confident that we will see that in the future as well.
And just on that last point in U.S. embassies, it was not too long ago that ICC indictee showed up at the U.S. embassy's doorstep in Kigali, and Rwanda is not a state party, the United States is not a state party, but there was a cooperation to have that transfer occur. So I think you're so right to point out that even these small little, that's a very big effort, but the small efforts that can occur at the U.S. embassy levels can be quite helpful to the ICC's work in the field.
Absolutely. Yeah.
Let me conclude, and then we'll turn over to the audience for questions. And again, I'll ask my colleagues to put the mics in the back here, so we can take questions at a time, and then the registrar can answer them. But let me conclude with an important, often overlooked mission. I know you mentioned it earlier, and that's outreach. A very important part of the court to actually demonstrate the work of the court, what it's doing to communicate accurate information. How is the ICC, and you're particularly well placed given your previous work at the ad hoc and hybrid tribunals, how's the ICC improved on the ad hoc and hybrids outreach efforts, and where there's still hurdles? And again, I always like to come back to where can states do more?
Yeah, I think that the problem to certainly with outreach is you can never do enough. As you mentioned, I've been based in Sierra Leone, in Freetown for 3 years. The Special Court for Sierra Leone had a fantastic outreach program. There was not a single village in the country where the court at the time was not visiting at least once or twice, and often under very difficult circumstances. No electricity, no nothing. But what you do is you have a pickup truck, you have a generator, you have a television, you have a video machine, and you go over there and show people that Charles Taylor, the former president of Liberia, is actually sitting in the courtroom and having a fair trial. That impact on the population is just absolutely amazing, and there's no way you can underestimate that effect. And when the Special Court for Sierra Leone was closing down in December last year, I was at a closing down ceremony, and the president of the country as well said, you know what, the success of the Special Court was basically a success of the outreach program. That was a relatively, compared to other situations where we were working on, that was a relatively easy exercise. It was a post-conflict situation. There was a genuine feeling amongst all political parties in the country that we had to move for a form of justice. All different groups were equally charged, were equally held criminally responsible. What we see now in our activities is that we're often in countries who are still in the middle of conflict, and where governments or rebel groups and whatever are absolutely not interested in seeing that our work is succeeding. So often the way that we can do outreach is much more complicated, And as I said, we can never do enough, but it is something that I think also the court itself should have a stronger strategy in order to develop more activity, but also there again, that is something where also states can greatly assist, either by providing for financial support for the court to do it, or also, as I mentioned before, by having their own channels of communication with NGOs, with civil society, and have court officials show up, present their work, or do training about what does justice mean, what does international justice mean, etc. But it is where I think civil society, states, and the ICC together can do a lot of work and achieve much more. I think international justice really depends largely on the quality of outreach, frankly speaking.
Is there, sorry, as a follow-up question, is there specific examples of outreach that the ICC is doing now? I know you mentioned some earlier, but the types of things that it's doing that you find are very productive, and how to even leverage that even more?
Yeah, I think outreach can mean so many different things. I think it's primarily focusing on making contact with local population, civil society organization, paramount chiefs or chiefs of local communities. When I was working in Sierra Leone, I regularly traveled around in the country, and the obligation that you have is as soon as you pass through a village, you have to meet with the chief of the village. You don't travel fast in that country, that's quite obvious, and certainly not if you have to stop every 5 kilometers. But it's incredibly, crucially important to have that commitment and to have that dialogue. And often to simply organize town hall meetings, which is not more than, you have a concrete building, so that if it rains you won't get wet, and then you talk about the court and what justice means. These are the kind of things that have a huge impact, and we should continue to do, should do more. And it's, again, as I said before, that's also where states can help us out.
And coordinating, as you said, the court, states, and civil society to do those efforts and to echo them where needed. With that, I'll turn over to questions from the audience. It'd be great if we could get 3 in a row, and that way we could then answer them thereafter. I see one in the back here. And when asking the question, please introduce yourself and any affiliation, and then we have one here in the front. So there's one right there in the back. Can you raise your hand? Thank you. And then if we could bring another mic to this gentleman here in the front, and then we'll get to your ma'am and your question.
Hi, I'm Holly Dragonis. I'm with the Enough Project here in DC. Thanks a lot for your talk. I'm just curious, with Prosecutor Bensouda's upcoming launch of her new policy on sexual violence prosecutions, what you see the role of the Registrar in supporting that in concrete ways, and if you have any lessons learned, best practice from your time at the special court or at the Yugoslav tribunal on that particular issue, particularly with regard to evidence for command responsibility on the heels of the Katanga judgment. Thanks.
Sir?
Oh, thank you. My name is Martin McMahon. I'm the managing partner of the Transnational Business Attorneys Group. Last year we filed a complaint with your court, and I think that was our 5th one, but I commend you for that court. Sorely needed. We represent a number of Muslims, do a lot of work in the Muslim community. Unbeknownst to me, these Bangladesh citizens came in and wanted to go after the current leadership in Bangladesh. So we drafted up a nice complaint, attached 181 media references, including New York Times, to show how serious this matter is. 200 citizens have been murdered, 100 journalists are either dead or have been missing. And I wanted to know, because it's coming up on the 1-year anniversary, is there somebody at the court, and I don't want to bother everybody, of course, but is there somebody at the court that I would send a letter to and say, I haven't heard from you guys, and Muslims continue to be murdered. Any recommendations on that? And I told the clients it would take 3 to 4 years, this process, if you have any input on that.
Thank you.
Thank you. And if we can get the microphone over, if you could raise your hand so my colleagues can see it. For you, ma'am, standing up.
Thank you.
And if you could just hold on to the mic for the next series of questions.
I just have a follow-up question
And if
on
you
the
can-
outreach.
Introduce yourself and your affiliation, please.
My name is Susanne Riveles. I'm with the International Alliance of Women. And I have experience in Sierra Leone and in Liberia with the court and with supporting projects that were collaborating with the court, with the tribunals there. But my question is different here. In a country where the country is not state party, what is your outreach program to raise awareness in these countries? Certainly include the United States.
Well, hopefully I can speak for the ABA and say we're trying to do our best in that regard, but that's
Very
three
good.
questions and we'll get our next series thereafter.
Okay, very good. First question about sexual violence investigation and new strategy from the prosecutor.
And all that we asked for is an investigation.
Well,
Yeah.
it was the
Yeah.
question.
I'll get to yours in a minute. I think that it shows the commitment from the prosecutor to this new strategy. I think the unfortunate thing that you see in every single large-scale violation of fundamental human rights and commission of crimes, you always see a huge sexual component, to put it in those terms. There's no single case where that has not been the case. And I think from that perspective, I have welcomed that as well. We have been participant in the preparation and internal coordination on this strategy. You know, we've seen in the Katanga case as well, that given the specific role that the trial chamber put Mr. Katanga in, who has established his responsibility, that they had a sort of disconnect between what his responsibility was and the foreseeable and not foreseeable consequences of the commission of sexual crimes. What I often try to emphasize is that the fact that someone hasn't been held responsible doesn't mean that those crimes have not been committed. And I think that is also what the trial chamber in this case has been identifying. To a certain extent, that shows, I think, also the frustration from the trial chambers that you can't come to that conclusion. Because as I said, you know, it's one of the most horrendous parts of crimes that are normally, unfortunately, committed. I think also in what it shows is that, and that is part of the overall strategy of the prosecutor, and although of course I can't speak on her behalf, but I think I take the liberty to doing it a bit anyway, is that there's a need to strengthen investigations anyway. She has a new strategy for a number of years to increase her capacity. She has, in my view, not enough investigative capacity to really properly investigate crimes. We've seen the first cases of the court where the final judgments are not necessarily really standing out as examples of international justice, to put it in those terms. And that is also something that Fatou Bensouda herself recognizes. And I think she is, in general, focusing on strengthening of her capacity and strengthening of the preparations of her cases. And this would include also that in the future, hopefully, those kind of situations where one of the most sort of obvious and concrete forms of commissions of serious crimes are being excluded from the final criminal liability. So I think there is a general feeling amongst many people in the court, of course, that this should be part, but of course, if you don't have the right evidence and all that, you can't go there. But it also shows that we better get our work, and also the prosecutor gets her investigations organized in such a way that in the future instances that will not be the case again. And her policy paper on this is a clear example of that she's very committed to that. What probably has happened with the case, but I took note, and we're more than happy to further bring that back to The Hague. This material probably has come to the prosecutor's office. Within the office of the prosecutor, they have a special section that deals with information that may not immediately be ready for a state referral or a referral from a country where they have the authority to investigate. But they investigate the material nevertheless, And then in due course they will come back, but you have to understand also that I think on a yearly basis they probably have hundreds if not thousands of cases that are being brought to them. The last one, outreach to non-state parties. Yes, that is good. I think this is, in my view, is an outreach offence. If you want to put that wide definition to it, and I have a wide definition of outreach. I think at the moment what we realize is, and as I said before, outreach can never do enough. You can't do it enough in the party where you do investigations. We had a recent discussion also in The Hague where we actually recognized also that rather than only doing outreach in the country itself, you also have to do outreach in the neighboring countries because they often are part of the same situation. You recognize yourself, if you do outreach in Sierra Leone, you also have to do outreach in Liberia, which we did at that time. With Kenya, you have to look in the countries in the region as well. With Mali, it's the same thing. These crimes simply seem not to be limited to the country itself. Those crimes have a cross-border effect, and that means that you also have to reach out. But it also means that the task is so incredibly huge that it's very difficult for the court to do it ourselves. Just to give you an example, in Kenya we have one person doing outreach. That's not enough. At the same time, unfortunately, among state parties, there's sometimes a tendency of saying, outreach is not your core business. Focus on your core business, focus on your judicial proceedings. In my view, that is not the right approach. I think outreach is an integral part of your judicial proceedings, and that's where I think, I'm not saying that the court can do it all on their own, but I say that in cooperation with other states, in cooperation with civil society organizations, we can and we should do more than we have been doing, including also in raising the profile of the court in countries that at the moment may not be state party, but where I think there is a use of having that discussion about whether or not that situation should change. I hope that answers your question. Yeah.
Just on that last point, it's worth emphasizing about the ICC, no matter how much resource it has, cannot do it all.
No.
And it's really, I implore everyone here and through different organizations is doing outreach as well. Through our organizations, through our networks. That's the only way that the message of ending impunity can really get out. And in that sense, I think we need to coordinate with ICC, and I know that the court itself is very open to this type of collaboration. Coordinate on accurate information and what needs to get out there, because that is so vitally important. I share with you, Registrar, on that point. We have a question here in the front, a question right behind him, and a question in the back. She has a mic. If we can get a mic to this gentleman behind her. Please state your name and your affiliation.
Hi, I'm Susan Wolfenberger. I direct the Geospatial Technologies and Human Rights Project at the American Association for the Advancement of Science. And so before you were mentioning a little bit about opportunities for lawyers at the court to participate, so I wanted to ask more about opportunities for scientists to participate with the court. So for example, I worked with the Deputy Registrar at the European Court to go to the court and provide a training about how to use remote sensing in litigation. And I was wondering if the ICC has a similar program opportunities that scientists can come to the ICC and share their information to the judges and the staff that are at the court.
Thank you, Mr. Ticket, for allowing me this question. I'm H.P. Schijnemachers from the Netherlands Embassy here in Washington, D.C. Mr. Registrar, I have a question. This country seems to favor ad hoc tribunals a little bit over a permanent structure as the ICC. Based on, you see that in the support the ad hoc tribunals have received or are still receiving from the United States. Can you comment, based on your past experience, on how important that support from the US has been for the ad hoc tribunals? And can you compare or give us a sense of what the advantages of a permanent structure are, for example, in cost savings, etc., over the ad hoc tribunals that you've been working on before? Thank you.
Coming back to your first question, as I mentioned in my introduction, at the moment, or so far, the way evidence has been presented to the court has primarily been based on witness testimonies. But at the same time, we've also recognized that that may be a weak system. And as soon as we're talking about witness protection issues, the problems involved on that, and also when time is passing, reliance on witness testimony does not always become higher as well. And I think many scientists also recognize that. So I do at the moment also see within, it's primarily the prosecutor's office more than my own office, a recognition that we have to go for alternative ways of identifying elements that can be used as evidence and can strengthen your case. And scientific evidence doesn't need to go into protection programs. Scientific evidence can simply be presented and has its value in the courtroom. So I do recognize within the courts and within the prosecutor's office that there is a willingness to look more into that. I do know that they're looking more into modern technologies as well. And more than happy to give your contact details as well to the prosecutor's office to also say, hey, are there possibilities of forms of cooperation? I know that there are contacts with forensic institutions in different countries, including in the Netherlands, but also other countries. So there are ways of strengthening that. Those forms of cooperation, telecommunications is a typical example of that. Computer crime issues, these kind of things. So there are elements over there, and again, it's more for the prosecutor, but I'm more than happy to pass on that.
Well, I have been working with the prosecutor's office, but this was more a question about just a general sharing the information with the people that work at the court, so that everyone is more aware of things that they might encounter.
Yeah.
So it was a little bit different than
Okay.
the prosecutor.
No, but I do recognize that, and also in the registry, on the registry side, we look into that as well. But most of it, of course, is primarily for the prosecutor in order to how to organize her cases. And I think that there is still a learning curve in terms of how much and how different scientific disciplines can actually contribute. And we probably don't have the full picture there yet. So any form of cooperation that we can see would certainly be extremely helpful. Finally, the question from you, HP, of ad hoc over ICC. I think the role that the US has been playing in relation to some of the other tribunals that I've been working with, the Lebanon Tribunal, also Special Court for Sierra Leone, has been absolutely tremendous. For the Special Court for Sierra Leone, the US was actually one of the biggest donors for the court. That court was based entirely on voluntary contributions from states, and the US was one of the biggest donors. And I spent many hours, many days here in Washington in order to lobby on at the Congress in order to make sure that funds were being channeled to the Special Court for Sierra Leone out of the bilateral programs between the US and the US appropriations towards the country of Sierra Leone. I'm not sure I always make myself very popular with the US ambassador in Sierra Leone because she felt I was taking her money in order to work for the Special Court for Sierra Leone. But it shows that there was a lot of commitment from not only from State Department but also from the Hill to see that justice was being done and that those courts could operate. But also in relation to the Yugoslav Tribunal, I think it's a public knowledge. There's a lot of information that was provided, also intelligence information that really made the breakthrough in cases before the Yugoslav Tribunal. I don't know exactly what the relations are between the US government and the prosecutor at the moment. It's not my business, but at the same time, I will be very surprised if there are no forms of cooperation. The advantage of a permanent institution is that you don't have to set up an institution every time again. And set up time for an institution at least takes about 3 to 4 years. In the Special Court for Sierra Leone was established in 2002 as well, but the trials really got started at the end of 2004, 2005. Yugoslav Tribunal as well, established in May 1993, but the first cases were only 95, 96, 97. So you see that you have a long way of lead-up time before you can become operational. The ICC is there, the institution is there, the expertise is there, the investigators are there. So if you make a referral to an existing institution, it makes it simply easy. You can react much quicker than in other institutions. Also, in terms of the closing down of ad hoc institutions, there's a bit of a funny challenge that I've seen myself with the Special Court for Sierra Leone as well. In very pragmatic terms, you know, if the judges who deal with the last cases, who have to work hard in order to finish off their case, it basically means that they have to work hard in order to make themselves redundant and to end their own contracts with an institution. It's a challenging motivation for people. You know, those kind of questions, also the legacy of material, the archives, what are you going to do with that in the future? These kind of things are much easier to deal with in a permanent institution than in an ad hoc organization where you always have to arrange for your own legacy, your own residual mechanism, where money is always necessary. And in the meantime, of course, people have moved on in the political attention. Who's interested in what happened 10, 15 years ago in Sierra Leone? Who's interested in the crimes that have been committed in the former Yugoslavia? That's so far part of history that it will be very difficult to preserve those kind of institutions for years to come. And that respect, permanent institutions, of course, are way more flexible and should be more appropriate to deal with.
We have time for a few last questions. I see one in the back there, and then there's one right next to. And these will be our last two questions. Please go ahead and your name and affiliation, please.
I'm Elizabeth Wilson. I teach human rights at Seton Hall University, and I'm also with AMEC, the American Coalition for the ICC. My question, actually I have two if I can sneak them both in. One is about the activities of the registry and the victim assistance in post-conflict situations, whether there's any kind of, or what the nature of training might be in non-violent conflict resolution techniques to, you know, kind of preemptively prevent things from taking a violent turn in the future. And the second is a legal clarification. I'm sure that there's a reason why this is not possible, but I'm just not quite sure what it is. In the Syrian situation, there are spillover effects in neighboring countries, some of which are members of the court. And I'm just wondering, are there any jurisdictional possibilities there, and what would have to happen in order to make that possible?
Thank you. And our final question is right next. You can raise your hand so my colleagues can see. Oh, you have it. Okay, go ahead. Please go ahead.
Hi, my name is Erica Carr, and I'm currently affiliated with myself.
That's always a good affiliation.
Thank you, I agree. I support myself. So you mentioned earlier that the self-organization of counsel on both the victim and the accused side could possibly really help the better functioning of the court itself. So I wanted to ask, what other sorts of organizations are currently supporting the functions of the court? What sorts of functions are they supporting? And what other functions could be better supported by organizations? What needs are there that aren't currently being met, that could be met by civil society or organizations of people who work within the court? Thank you.
All right,
Yeah.
very good. Victim assistance. As I mentioned before, I think the different aspects of victim participation and victim assistance as well. I talked about the role of victims in our legal proceedings, but I think your question is more as to what happens with victims also on the ground. What do they see of the fact that the court has been dealing with the situation there? And this is where, again, I think the Trust Fund for Victims has a huge role to play. And it is what we often refer to as more sort of reparative justice, where you know, the example I gave of the women in the eastern Congo have been the victim of sexual crimes have also been sort of almost expelled from their own societies. You know, they're suffering where in principle to go on for the future as well. By having more of an overall approach to the situation and bringing in people as well and actually recognizing that, hey, wait a minute, those people are victims. Don't victimize them more by excluding them from your society. Integrate them in your societies again, in your local communities, etc. And the way that was presented to me basically showed that, hey, that works. Those people have a future again for themselves. So these are elements. I can also mention that there are other projects possible where you actually have a confrontation between victims and perpetrators. I'm not aware of any specific examples over there, but I would imagine that also the Trust Fund for Victims could focus on these kind of activities, and also together with civil society organizations. Let's not focus on only those few people that may stand trial in the end in The Hague, because the number of people that will stand trial is always extremely limited, and the number of victims and the number of perpetrators is always extremely high in most of the countries that we do investigations. So rather than focusing only on those 2 or 3 cases, or sometimes a bit more, even in Sierra Leone, we only were able to finalize 9 cases against 9 persons, although the number of perpetrators have been, of course, in the thousands. And what I think we should be focusing much more on, and it's not only a role for the ICC, but also for civil society organizations, also for states parties maybe to focus on those projects, is to see how you can bring more, not only confrontation, but a meeting of victims, perpetrators, and how that would work. I do recall one example that was mentioned to me when I was in Eastern Congo, that there was at one point an event where perpetrators came forward and actually were able to tell to the victims of where huge killings had taken place, and the perpetrators were actually able to say, you know what, I recall that I was, or my team was responsible for the killing of that person, and actually we did it at that and that point. So they were able to dig up the bones of the people over there, and actually for the victims, it was an element of, call it justice for them to actually see that, hey, wait a minute, now I know what happened to my beloved ones. I have found my family back, so to say, and we've been able to do a proper burying or something like that. That is also a form of justice, and it goes way beyond the principal judicial institution that we are ourselves, but it's something that we have to work much more on and go beyond the probably more Western idea of pure sort of justice in the more traditional sense. Syria spill over to other countries. Yes, I recognize that, and maybe there are. If we look at Jordan, who is a clear state party, if there are possibilities over there, that certainly might be something that you could look into, where maybe NGOs can assist as well with maybe victims over there. Depends, of course, very much on the kind of victims, the kind of perpetrators, whether they are there. I bet there are, of course, also people who have committed crimes in Syria who have since been going away. I recognize, for example, from Holland that there have been people who have been recruited from Holland going over to Syria, fighting with different factions in Syria, and then have come back. Maybe there's a role for states to investigate the crimes that those people have been committing as well. So you're not completely without any power over there, but of course, to be perfectly honest, I think the most positive way of bringing justice, of course, would be to have the Syrian case itself referred. That's where the massiveness of the crimes have been committed. What you're able to do is pick up on bits and pieces, but maybe here also make a reference again to the Iraq investigation that the prosecutor is doing. Many crimes were committed in Iraq. There are allegations of UK soldiers that have committed such crimes as well in Iraq. They have come back. You know, there's an investigation that has been going on. The case has been presented to the prosecutor, and the prosecutor said, these allegations seem to be very serious. That provides me a basis of doing a preliminary examination. And so you are able to focus on crimes that have been committed in Iraq. So these kind of indirect ways are able to be done as well. But does it come to the core of the case? Probably not. The last question, I'm not sure I really understood your question. Maybe you can explain a bit. Sorry for that.
No, it's okay. I was just intrigued that you mentioned that the self-organization of counsel could possibly help with the actual functioning of the court.
Yeah.
You talked about people being on a list. Maybe the organization could create that list instead of the court doing it, that sort of thing. So I was wondering if there are any other functions of the court that organizations already support you guys with, and what are the needs that aren't being met that organizations where they could get the slack a little bit and help the court function better.
I think yes, and I think I think I would primarily think indeed about the issues that we already discussed. You know, outreach, information to what happened in different countries, and I recall again my experience in Freetown, where we had monthly meetings with roughly about 40-50 different civil society organizations, national civil society organizations, who had their own outreach events as well in Freetown, in the rest of Sierra Leone also. And these were not necessarily always 100% positive about the court, but I didn't mind about that. What was important is that they entertained, they also organized a dialogue about what does justice, what does international justice mean for the people in the country. And that is where I think, civil society organizations all over the world, international organizations, but also local organizations can assist. And I can tell you, we do have a lot of contacts from out of our press office with organizations in the countries, but there again, there's always more that you can do and should do. Because by the end of the day, what you want to achieve is basically that people feel like, hey, wait a minute, what you guys are doing is what we want for ourselves. At one outreach event in Sierra Leone again, one of the conclusions that people were drawing in the room was sort of, hey, this is all nice, but we show what we see from Charles Taylor being in The Hague, having a good counsel representing him and all that. That's what we want for ourselves as well. And I think that is the major thing in order to also strengthen the capacity of states themselves in order to investigate those crimes and prosecute crimes. The court is a last resort. We can only do very tiny little things over there. The majority, the vast bulk of what requires justice mechanisms has to be done at a national level. And it's these kind of activities, I think, where civil society organizations, bar associations, etc., can really play a big role.
Well, with that, I first would like to conclude remarks and thank all of you for being here, especially on such late notice. It was, I think, a healthy conversation, and as the registrar said, this is a form of outreach. This is getting the information out and talking about the court and its activities. I want to thank the Washington Working Group on ICC, and in particular the Baha'is of the United States, for their support of this, of our lunch here and of our activities. And for those in the room who don't know about the Washington Working Group on ICC, it's an informal coalition of organizations with offices here in Washington, D.C. to work on advocacy and education on the International Criminal Court. And the ABA Center for Human Rights is happy to be a member. And then one point of clarification, our website is going live. It's at the bottom here. In the coming weeks, you can see the video of this event on there. It's on the back side of this brochure. But most importantly, also, thank you very much, Mr. Registrar, for being here with us today. Your insights are very helpful. Thank you very much.